Welcome to Future First Criminal Law's live stream video here. I am Zachary Divalbus, owner of Future First Criminal Law. This video is the second part of what we call the journey through the criminal justice system. This journey, as we're taking it yesterday, followed more of a flow chart, and this time I've created a template that allows us to see different stages of the criminal case, of a criminal process. This PDF that I have here will be available online. I do want to say it's not all inclusive. There's so much that goes into every criminal case, but this gives a big general outline of some of the big topics, some of the things that happen that most people are stressed about, worried about. And if you or loved ones going through a case in the felony Arizona criminal justice system, you definitely want to have a private lawyer, good representation to make sure that you don't have to understand the complexity of all this. This video is here to help give you an understanding, but it is not here to replace the fact that you need a good criminal defense lawyer. Sometimes that is not the one that is appointed to you, which means you have to go out and find them yourself. So hopefully this video allows you to get a little more of an understanding of what you're looking for, the type of questions maybe that you might be asking, and what you're going to see, at least from our perspective, that many people have asked about. So the journey through the criminal justice system, we want to first start off by saying every situation, every case is unique. Every case follows a similar process, but kind of moves in like a chessboard where we can move different pieces at different times to get hopefully the best results possible. Anyways, every case starts with the booking. So this is really after an arrest has been made or after an indictment, after the police have been involved in some sort of investigation, there's a booking. The booking is in our jail, at 4th Avenue Jail here in Maricopa County. It's the place where everyone gets processed for major felonies. Some of the lower level misdemeanors might go to the city court locations and the city court jails. But ultimately, if you're going to be facing felonies, you will then be transported to 4th Avenue Jail. This is where they get there with a handful of questions. Definitely don't take any drugs, any paraphernalia, any weapons into jail. That technically is a much worse, more serious crime at this point. This is the part where you'll be photographed, fingerprinted. They go through the standard questions, what's called a Form 4, where they fill out all kinds of little background on you. At this point, don't be uncooperative in the sense that you're fighting, swearing, punching a police officer, but you definitely have a right at this point to still be under oath to not speak with the police, to provide any kind of statement. Typically, most of this information here is just background information, so that way they can put you into the system so somebody can eventually find you and let you out of it. What we get into next is the post-arrest investigation. Once again, not an all-inclusive list here, but this is very important. Not a lot of people talk about this. This is the part where sometimes within your case, you may be facing this. This is where after you're arrested, there might be doing some follow-up investigations. So they might be putting you in a lineup. They might be getting handwriting samples and voice recordings. Yes, that is a real thing that the police are allowed to do. They're allowed to collect hair, saliva, a little more on the rare side, but it typically, it isn't going to happen, especially without our court orders. Not our standard type of case this early on, but I want you to be aware that this does come into play. Especially if you have a DUI case, whether you're at the city jail or the county jail, the 4th Ave. They're likely going to get you to try and do the blood test or a breathalyzer test. So understand that that's what we're talking about here as far as the post-arrest investigation goes. I will give one very small tip here when it comes to DUI cases. If they do ask for you to give your blood, you will have to give that blood, or else your license will automatically be suspended for 1 year. So that's one thing that you want to avoid. If you say, no, you can't have my blood, then what happens is they go and get a warrant, they hold you down, and they get your blood anyways. So better to give it to them actually the easy way there, saves you a license suspension, and then pretty much don't do anything else as far as that goes. Please refer to some of our other YouTube videos on DUIs and the whole process there, because there's a ton of information. That's just a quick freebie there. Most people are not aware of that one. Anyways, this is where they're going to try and get consent to search more of your property, more of your person, a house, a car, vehicle, any of those things. And then the last bullet point we have here is the interrogation. This is where they're going to give you Miranda 9 times out of 10. They're going to start asking more questions. They want to appear to be on your side. You're just there to fill in the blanks. Well, quite frankly, you're already arrested at the police station. This is really the time not to talk. Ask for a lawyer. Don't say anything until you do get a lawyer. Even if you can't get a lawyer to show up that day, that night, you don't have to say anything. It's better to solve it a week, months down the road than to say something that you can't undo to the police there. Continuing on, then we get to the initial appearance. The initial appearance, very standard for any case, but sometimes people don't realize that this is a true appearance. This is where after you've been arrested, you've been booked in a jail, you must see a judge. That's what we mean by judicial officer. You must see a judge or else they can't legally continue to hold you beyond a certain amount of time. This, in our court process, we have judges who are on the bench 24 hours a day, even at night. They pretty much go in a couple hour intervals, so it's not like they're just going to be in a big rush to see you if it's 3 in the morning or anything like that. But you definitely won't go past 24 hours without actually seeing a judge. At this time, the judge goes only through a handful of things. So it's a very quick process, not the moment where you usually even get a defense attorney. There's usually not even a prosecutor there. You and a bunch of other people who got arrested during that day or that night. This is where the judges are going to basically, in a very quick and concise manner, tell you that these are the charges that you're facing. They'll give you a copy of it. They'll be on your release order. On part of that release order will be the notice of your rights, pretty much the right to remain silent, your right to counsel. Will also likely give you a public defender, or at least do a financial statement at that point saying that you are eligible for a public defender. Going down through the next steps of your case, you won't actually get a public defender right then and there. This is where they will talk about bail or bond here in Arizona, the release conditions. How are they going to either keep you in jail as your promise to appear, or they're going to say, here's OR, your own recognizance release conditions, which means you're promising that you're going to show up to every future court date and they're not going to have to put an ankle monitor on you or anything along those lines. Or there's going to be a financial burden, a cost, which is your promise to appear. And if you don't show up, then they get to take all that money that you already paid. And this is where they set up a preliminary hearing date. Understand that in our felony cases, the preliminary hearing date for this context means a few different things. There's usually status conferences, indictments, all this other kind of stuff that is in other videos. But ultimately, they're setting up the next court date. That's what's most important here as part of what the release conditions are, how you get let out of jail, and the fact that you have a future court date coming. One of the things that I did include in this that is important is on the misdemeanor side of things. You're going to be pleading not guilty. Very difficult still at this point to plead guilty. What typically happens is in the felony process here, and if you're charged with a misdemeanor, the judge technically is allowed to hear you say the word guilty and then could move on. Most of the times they'll boot you out of that system and they'll jump you into the justice court system anyways and just plead not guilty for you. But for sure, if it's a felony case, you're going to be pled not guilty because they have to move you through the process here. This isn't your arraignment. This isn't a pretrial conference. This is purely what they call the initial appearance. It's supposed to be very quick, very brief in order to process people into the system and hopefully get them out as far as release conditions go. But if you don't get out of jail, then it is going to be a much longer process for you. Continuing on, we get to a preliminary hearing. So I know this cuts out some of the processes, some of the steps that we talked about in the flow chart, but ultimately the preliminary hearing is classically what happens next. This is your right to the probable cause hearing. This is your next step as far as the arraignment goes. This is more of, this allows the judge to go forward with your case. It allows us as a defense team to get more evidence, more discovery. This probable cause determination, as described in some of the other videos, purely is a very low standard, basically for the judge to say, okay, was there a crime that was committed, and is it possible that you were the one who committed that crime? Super, super, super low standard. They bring in one police officer to talk for like 10 police officers. All of this is allowed. Very difficult to win a case this early on, but it definitely is possible. Won't discuss it in this video, but there are some reasons why you may not want to have a preliminary hearing due to some advantages and disadvantages that we get to play with here in Maricopa County. Continuing on, if there is no probable cause found, then great, your case will be dismissed, it goes away. Of course, there's statute of limitations. There's all kinds of different legal things that could come into play, which might bring up charges again. But ultimately, if you are found responsible, or excuse me, if you are found with probable cause, then your case gets to move on. Then we move into the not guilty phase at the arraignment. Then we start the formal process. We make sure you have a public defender at that point or a private attorney will be able to come in at this point in order to go through and talk about plea bargaining or the trial process moving forward. Continuing on, we have a brief note in here about what plea bargaining means. Plea agreement, plea offer, plea bargain, all the same word, all synonymous here. What this really means is you want to finish your case without trial. There are whole videos that go into plea bargains, especially on our felony level here, definitely our misdemeanor side, in order to help explain really what plea bargains do. So this is just such a little tiny scoop out of the ground of what this really means. But essentially, a plea deal is negotiations between your representation, your lawyer, and the prosecutor, which is the lawyer for the state of Arizona, essentially the lawyer for the police. And the idea is that a plea bargain will allow us not to go to trial. Well, you might have a very big benefit of going to trial. So hopefully the state then recognizes that if they give you a better deal than the potential outcome if you were to lose at your trial, then that's what a plea bargain does. Or at least that's the goal. It's very frequent that we don't get good plea offers, especially right off the bat. But something that is not going to be the same, or let's say it is the same as if you were just to go to trial anyways, then we might not want that plea agreement at all. We might as well then just go to trial, roll the dice, and let's see if we can win at trial. Very rare that actually happens because the prosecutors are usually smart enough to give a better plea deal than if we were to go to trial and lose, or else it defeats the whole purpose of the plea deal system here. Anyways, a judge must actually approve that plea agreement, which means it must be legally valid. Very, very high standards there. That's what every criminal defense lawyer, every prosecutor, every judge is trained to do, as long as we have formal training like we do. But it is possible to make mistakes, and so that's something that you don't want to have happen. You don't want a mistake to happen in your plea agreement, because guess what? You're never going to get the better end of a mistake here. Continuing on, you want to make sure that you never accept a plea agreement without discussing with a lawyer, whether it's a felony, whether it's a misdemeanor at all. Pre-trial proceedings, this is a huge term. All kinds of different things happen here, but the main one that you really are usually most concerned about is what we call discovery. In the criminal justice system, we don't call everything evidence, we don't call everything police reports. Discovery is the real word. This is the legal term that allows us to find out different things. It's the huge umbrella that covers all the pieces of evidence that most people are worried about. So, anyways, there are mandatory disclosures, there are voluntary disclosures, all kinds of exculpatory evidence. All these things have to be disclosed and exchanged in certain ways with certain letters and certain formats. It takes sometimes a while to download, especially videos these days. Much better than it used to be, which is a good thing, but either way, kind of a slow process here. This part of the pre-trial process is usually what takes a while on our end and on the prosecutor's end, and everybody's sitting and waiting, especially for it to happen. This is where we can go through, do additional requests for discovery to try and gather more evidence for you. Some cases we can always get more, some cases you can't. Then this is where we also talk about the discovery process and potentially filing motions to get certain pieces of evidence. Not every day that this actually has to happen, very rare, in fact, because the prosecutors know they have to turn over really every piece of evidence, and it's very rare that they actually keep anything from us, because if they do and we find out, then that's a good way to lose your license, which they don't want to do. One of the things that this follows upon is if there are legal issues in your case. All kinds of different legal issues we can have. Won't get into it in this video, but this is where we get to start filing motions that go to the prosecutor. The prosecutor gets a chance to file a rebuttal motion to say that, hey, the defense attorney was wrong, I'm right. We get a chance to then file another motion to say, hey, actually the defense attorney is right. bunch of legal back and forth here. The judge is basically the referee on this. A lot of people will say that the judge will just follow the law. They'll do everything that's right. Well, a lot of times the judges don't really know every single thing. Every single case is different. The judge doesn't get to read the police report, watch the videos just like we do. So the judge is really there to make sure the law is followed and that the legal process actually happens. Then they get to basically make the decision whether to approve a request or to deny it. Now, if a case is not resolved by the pretrial process, by a plea agreement, with any disclosure issues, motion issues, negotiations, then we must move to the trial process. There is no way to stop a case from getting to the trial process unless it's dismissed, which means every case must end with a trial. That's why plea bargaining is so beneficial, because a lot of people think, well, if I don't get a good plea agreement, then maybe the whole thing will just go away. It's not true. Your case will eventually end up in a trial. So trials, very standard process, very common here in Maricopa County. Begins with jury selection. Then we go to opening statements. Then the prosecutor gets to bring in the evidence against you. This is the police officers. This is videos, dash cams, anything that happened there. We get to cross-examine, which means ask questions of those police officers, try and poke holes in their story, talk about, maybe why they did or didn't do something, get into their credibility. Then it's our turn to present. As the defense attorney, we may want you as the defendant to testify or not to testify. We may have been able to find other expert witnesses to maybe say that something the prosecutor and the police officers did or said was wrong. All those different things come into play here. The prosecutors, if you get to testify, will be able to ask you questions. And then ultimately any other witnesses will come into play here if there are any witnesses. Typically there's not in most situations, just based on the nature of some of these crimes. You don't really want your co-defendants testifying for you, and they don't have much credibility. Either way, towards the end of the case here at trial, the prosecutor and the defense attorney, we will get what's called closing arguments. That's where we get to try and tell the jury, and it's a final way to convince the jury to side with us. Then ultimately the jury will then go and deliberate until they reach a unanimous verdict, meaning they all agree whether you're guilty or not guilty. When the jury comes back, we then get to sentencing. If the jury finds you not guilty, then great. Your whole case ends. You get to go home that day. Nothing really else to do. The prosecutor could potentially appeal if there was something that they believe was done wrong. But the bigger thing is if you're found guilty. If you are found guilty by the jury, then it's not right then and there that you go to jail or anything like that in many situations. The jury does not get to decide your punishment. So what happens is the judge then sets out a new court date in the future, about 30 or 60 days into the future, in order to do official sentencing, where the judge gets to determine what your punishment will be. The judges have guidelines, all things that your defense attorney should have talked to you before you went to trial, which is part of why sometimes it may be more beneficial to accept a plea agreement than go to trial. But ultimately the judge pretty much has their hands tied on what they can or can't do. We as the defense attorneys try and get the lowest punishment possible. Prosecutors try and get the most punishment possible. But ultimately whatever the judge decides at that point is final. Of course there are appellate rights if something legally went wrong during your case, but ultimately that ends it. That really finishes the journey that is what we call the criminal justice process. I know I went through this in a quick manner. There's a ton of information that this video did not cover. And so if you have any more questions, if you're confused about the processes, if there's something specific you want to know about, then please feel free to reach out to us. We're here to answer questions. We're here to represent you if you have a criminal case. You definitely should not in any way feel as if you don't trust your attorney. And we want to make sure that if you don't, then you can move over to us and we can help solve your case for you. Thank you very much, and we really hope you have a great rest of your day and you reach out with any questions you